I mailed the invoice, certified, return receipt requested, $98,500, itemized down to the dollar, 61 pages of dated, time-stamped photographs stapled behind it as backup. Karen Ostrander called me 40 minutes after the mail carrier confirmed delivery, and the first thing she said before anything resembling a greeting was, "This is absurd, Grady. You cannot possibly enforce this." "I can," I said, and I did. "You should read page 4. That's where your own motorhome starts showing up 41 consecutive days on land you never once asked permission to use." She hung up on me. She called her attorney next, according to what I'd eventually learned during discovery. And her attorney, to his credit, apparently spent about 20 minutes reviewing what I'd sent before telling her, in language I only heard secondhand, but which I'm told was considerably more direct than lawyers usually bother being with a client who's about to be extremely unhappy to hear it, that the fine was not only enforceable, it was underestimated. Before I explain exactly how a half-acre of vacant commercial land next to Brookstone Commons turned into a $98,000 reckoning for the HOA president, who spent a year treating it like her own private overflow lot, you should understand who I am, because the reason that invoice held up the way it did wasn't luck. It was 29 years of knowing exactly how to make an enforcement action stick. My name is Grady Osment, 57 years old, 29 of them spent in municipal parking enforcement, the last 11 as a supervisor overseeing citation policy, towing contracts, and private property enforcement compliance for a mid-sized city before I retired 3 years ago and started doing part-time consulting work for commercial property owners who wanted their parking enforcement actually to hold up if it ever got challenged, rather than the kind of hand-lettered "No parking" sign that looks official right. Up until somebody's lawyer points out it fails every requirement the state's private property towing statute actually demands. It is, I promise you, a considerably more specific and technical field than most people assume, and it was, for 29 years, the entire shape of my professional life. I've testified in more small claims and municipal court hearings than I can accurately count, mostly on behalf of the city, occasionally as a private consultant once I retired, always making the same essential argument in one form or another, that a property line and the rules an owner is legally entitled to enforce along it don't bend simply because enforcing them inconveniences somebody who's gotten comfortable ignoring them. My wife Denise, who spent her own career as a paralegal at a firm downtown before she retired 2 years after I did, used to joke that between the two of us, we'd spend our entire working lives making sure other people's assumptions about what they were allowed to do held up to actual scrutiny, and that it was really only a matter of time before somebody tested that instinct on our own doorstep instead of somebody else's. I bought the half-acre lot next to Brookstone Commons 8 years ago, a flat, cleared parcel zone commercial, sitting directly adjacent to the development's clubhouse and community pool, purchased as a long-term investment against the day I'd eventually build a small self-storage facility on it, a project I've been slowly permitting through the county at my own unhurried pace. The way a person handles a project, they're in no particular rush to finish. For most of those 8 years, the lot sat empty, mowed twice a season, fenced along 2 sides, otherwise unremarkable, and Brookstone Commons' 240 homes went about their business without much reason to think about it at all. That changed roughly 14 months ago, when Karen Ostrander became HOA president and inherited, along with the role, a genuinely real problem the association had never adequately solved. The clubhouse and pool, built in the development's first phase back in 2004, had a parking lot size for a community half Brookstone's current population, and every warm weather weekend produced exactly the kind of overflow chaos that makes people irritable and bored start looking for the path of least resistance rather than the path of least liability. The path of least resistance, in Karen's case, was my empty half-acre. It started small enough that I genuinely didn't mind it at first, a handful of cars parking along the fence line during particularly busy pool weekends, easy enough to overlook. It escalated the way these things tend to once Karen's board began actively directing residents to use it. I still have the HOA's own summer newsletter, forwarded to me eventually by a resident who thought I ought to see it, which included, under a section titled Parking Reminders, the sentence, For overflow parking during pool hours and community events, residents and guests are welcome to use the additional lot adjacent to the clubhouse. No name, no owner acknowledged. Simply an unambiguous, community-wide invitation to park on land Karen Ostrander had never once contacted me about, let alone receive permission to designate for anything. I called her directly the first week I saw that newsletter, polite, entirely reasonable, explaining that the adjacent lot was my private property, that I had no objection to occasional, limited overflow use during genuine emergencies, but that I could not have the association formally directing residents to treat it as a standing amenity, both because of my own development plans for the parcel and because, as I explained to her plainly, drawing on 29 years of exactly this kind of conversation, uncontrolled use exposed both of us to liability neither of us actually wanted. Karen's response, that first call, was the initial sign of exactly how this was going to go. Grady, I appreciate you reaching out, but honestly, it's an empty lot. I don't see the harm in residents using it a few weekends a year. It's not like you're doing anything with it. I appreciate that it looks that way, I said, but it's still my land, and I'd asked that the newsletter language be corrected and residents be redirected to street parking or a shuttle arrangement for overflow events going forward. I'll take it under advisement, she said, in the particular tone of someone who has already decided not to. I want to be precise about something here, because it mattered enormously to everything that followed. An HOA president publicly inviting residents to use privately owned land she has no legal interest in, without the owner's consent, is not a minor courtesy oversight. It is, depending on how it's handled going forward, either a quickly correctable mistake or the beginning of exactly the kind of institutional trespass this entire story eventually became. I gave it another month before I did anything further, mostly out of the same instinct that had served me well across 29 years of exactly this kind of dispute. Document first, escalate only once the documentation is airtight. I photographed the lot every weekend, dated and time-stamped, logging license plates, and I noticed, within the first 3 weeks, a pattern that would eventually matter more than almost anything else in this entire case. A cream-colored Winnebago motorhome, plates registered, I confirmed through the state's public vehicle registration lookup, to Karen and Douglas Ostrander directly, parked in the same spot along my back fence line. Not for a weekend, but continuously day after day, clearly being used as informal extra storage rather than anything resembling occasional overflow parking. I called her again. Karen, I need the motorhome moved. That's not overflow parking, that's long-term storage on my land, and I need it gone by the end of the week. We're between projects on our driveway resurfacing, she said, and there's genuinely nowhere else to put it. I don't think a few weeks is going to hurt anything. It's been 3 weeks already, I said, and I want to be clear with you, because I don't think this is landing the way I need it to. This isn't a request I'm making as a favor. It's private property. You don't have permission to store a vehicle there, and every day it stays is a day I'm entitled to treat as a documented violation. Grady, I really think you're overreacting to what's a pretty minor inconvenience, she said, the particular brightness in her voice of someone who has decided the conversation isn't worth taking seriously. I run a community of 240 households. I don't have time to personally manage every small logistics question that comes up, and honestly, most people will be glad to help a neighbor out during a home project. I'd be glad to help a neighbor out too, I said, if a neighbor had asked me first, rather than an HOA newsletter telling 240 households my land was available without ever mentioning my name. She didn't have much of an answer to that, beyond repeating that she'd look into it, a phrase that, over 29 years of exactly this kind of conversation, I had learned to recognize as functionally identical to no answer at all. It was by the time she said that, already the 4th week. I did what 29 years of exactly this kind of dispute had taught me to do next. I posted proper signage. Not the kind of sign most private landowners put up, hand-lettered on a piece of plywood, legally meaningless the moment anyone actually challenges it. I mean the specific, statutorily compliant signage the state's Private Property Towing and Enforcement Act requires for a landowner to legally recover fees or arrange removal of unauthorized vehicles. Signs of the required minimum size, posted at every vehicle entry point, stating the property is private, that unauthorized parking is prohibited, listing the name and contact information of the property owner or their designated enforcement agent, and specifying the fee schedule that would apply to any vehicle found in violation, all of it filed, as the statute also requires, and which almost no private landowner ever bothers to actually do, with the county clerk's office as a matter of public record before the signage goes up. I want to explain why that filing step matters so much, because it's the single detail most people get wrong, and it's the detail that made every dollar of the eventual invoice hold up under exactly the scrutiny Karen's attorney tried to throw at it. Most private, no parking violators will be towed. Signs you see nailed to a fence post somewhere are, legally speaking, closer to wishful thinking than enforceable notice, because the property owner never filed the required fee schedule with the county, never confirmed the signage met the minimum size and placement requirements, and never established, in a form any court would actually recognize, that the person parking there had genuine, documented notice of the consequences before the fees started accruing. I'd spent 29 years watching exactly that mistake sink otherwise legitimate enforcement actions, city and private alike, and I was not going to make it on my own land. I filed my fee schedule the same week. A $50 initial violation fee per vehicle per day, escalating to $150 per day after the first 72 hours for any vehicle not removed following posted notice, structured deliberately, the exact way the statute contemplates a landowner recovering the genuine cost and inconvenience of unauthorized long-term use. Not a punitive number invented on the spot, but a schedule any private commercial parking enforcement consultant, myself included, across 29 years of exactly this kind of work, would recognize as entirely defensible and, more importantly, entirely typical for the industry. I sent Karen formal written notice the same day the signage went up. The motorhome and any other unauthorized vehicle on the lot going forward would be subject to the posted fee schedule, retroactive to the date of the notice, with removal arranged at the vehicle owner's expense if fees went unpaid beyond 30 days. Karen's response was not to move the motorhome. It was to send her own HOA-wide email, forwarded to me within the hour by the same resident who'd sent me the original newsletter, describing an unreasonable and hostile neighbor threatening excessive fines over routine community parking. Language that once again made no mention of the fact that the routine community parking in question was, by that point, a personal motorhome belonging to the HOA president herself, sitting on private land for going on 6 weeks without permission. What happened over the following 2 months turned what could have been a simple, quickly resolved boundary dispute into something considerably larger. Karen did not move the motorhome. She did not correct the newsletter. Instead, according to Trent Falk, a board member who called me directly 9 weeks into the dispute, increasingly uneasy about the direction things had taken, Karen doubled down at the board's own monthly meeting, describing my posted signage as an aggressive overreach unlikely to hold up if actually challenged, and instructing residents, through a follow-up newsletter I also eventually obtained, that the adjacent lot remains available for community parking regardless of recent signage, as the association believes the property owner's claims are unlikely to be enforceable. Trent asked to meet me in person rather than just talking over the phone, and we sat down at a coffee shop near the development the following week, him considerably more anxious than I expected a longtime board member to be over what still looked, from the outside, like a fairly ordinary neighbor dispute. "I've been on this board for 3 years, he told me, turning his cup slowly on the table without drinking much of it. I raised a concern at the last meeting about whether the board had any actual legal basis for telling residents your signage didn't matter, and Karen told me, and I'm quoting this as closely as I can remember it, that she dealt with plenty of overzealous property owners before in her old job, and that most of them backed down the moment anyone pushed back with confidence. He shook his head. "I don't think she's ever actually read your fee schedule. I don't think she's read the statute either. I think she just assumed, the way she assumes most things, that being confident about it would be enough." I want to underline that sentence because it became, once litigation actually started, one of the single most consequential things Karen Ostrander ever put in writing. The sitting HOA president formally advised 240 households in an official association communication to continue using private property she had no legal right to authorize, specifically because she personally doubted the enforceability of properly posted, statutorily compliant private property signage she had never once actually reviewed against the statute herself. I continued documenting methodically the same patient, unglamorous habit that had defined 29 years of my professional life. Every weekend, every vehicle, dated and time-stamped, plates cross-referenced against the state registry, violations logged against the posted fee schedule exactly the way the statute required for the fees to remain enforceable rather than punitive and arbitrary. I kept a simple spreadsheet, the same format I'd used for citation logs my entire career, 1 row per vehicle per day, plate number, time observed, duration where I could establish it from repeat photographs, running total against the posted schedule. Denise used to tease me, watching me update it most evenings at the kitchen table, that I'd apparently never actually left the job, just changed which parking lot I was standing in. The motorhome stayed for 41 consecutive days before Karen finally moved it, not in response to my notice, but, according to Trent, because Douglas Ostrander's driveway project finally finished. 63 separate guest and resident vehicles, over the same 2-month period, parked on the lot in direct response to Karen's own newsletter instructions, each one photographed, each one logged, each one accruing fees under the exact schedule I'd filed with the county before any of this had escalated past a single polite phone call. I called Priya Anand once the total crossed $30,000, mostly to confirm I was reading the statute correctly before I let the number climb any further. "Grady," she said, once I'd walked her through the documentation, "this is about as clean a private property enforcement case as I've ever reviewed. Your signage is compliant. Your fee schedule is filed and reasonable. And you have the HOA president's own written communication instructing residents to disregard posted legal notice specifically because she doubted its enforceability without ever checking. That last part is what turns this from a straightforward invoice dispute into something with real institutional exposure for both her personally and the association. I let the fees keep accruing for another 6 weeks. The same patient calculation that had served me across an entire career. The more complete the documentation, the less room anyone eventually has to argue the number was invented rather than earned. I sent the invoice the week the total reached $98,500, addressed to Karen Ostrander personally rather than to the association on Priya's specific advice, given that the motorhome violations were unambiguously hers alone and the guest vehicle violations traced directly back to her own written instructions rather than any board vote or official association policy. The 40-minute phone call that followed, the one where she told me the fine was absurd and I told her to read page 4, was, in hindsight, the moment Karen Ostrander could have still resolved this reasonably with a negotiated settlement and a quiet correction to the newsletter. She chose instead, once her own attorney's initial review apparently confirmed the fine was enforceable rather than absurd, to escalate. She filed a countersuit within 2 weeks, arguing that my signage, despite being facially compliant with the statute, had not been adequately conspicuous given the lot's proximity to the clubhouse, and that the fee schedule, while filed, represented an unreasonable and punitive rate designed to entrap rather than genuinely deter. She organized what she called an emergency board session, framing the entire dispute to residents as a neighbor attempting to weaponize a legal technicality against the community, language that, once again, made no mention of her own motorhome, her own newsletter, or her own written instruction disregarding posted legal notice. Trent Falk attended that meeting and recorded most of it, sending me the file that same night with a short note. You need to hear the part where someone asks about the motorhome directly. According to the recording, a resident named Priscilla Aoyama, who'd lived in Brookstone Commons for 11 years and had never once, by her own account, paid much attention to HOA politics until a $98,000 dispute made it impossible to ignore, stood up midway through Karen's presentation and asked plainly whether it was true that the majority of the fine stemmed from the board president's own personal motorhome sitting on the disputed lot for 6 weeks. Karen, according to the recording, did not answer the question directly. She said the matter was under active legal review and attempted to move to the next agenda item. Priscilla did not let it go, asking a second time, more pointedly, whether Karen intended to reimburse the association for any legal fees being spent defending what appeared, based on the newsletter records already circulating among residents by then, to be primarily her own personal parking dispute rather than a genuine community issue. A second resident, a man near the back whom Trent identified afterward as someone who'd himself received an angry response from Karen the previous summer after questioning a landscaping contract, added, loud enough for the recording to catch clearly, "This is the second time this year we've found out the board was covering for the president's own decisions instead of the community's." A ripple of agreement moved through the room. According to Trent, several residents nodding or murmuring in a way that made clear the sentiment wasn't isolated. The silence that followed Priscilla's original question, Trent told me, stretched long enough that people in the back rows started talking quietly among themselves, the specific sound of a room recalibrating its confidence in the person running the meeting. The hearing, 5 months after I first mailed that certified invoice, was shorter than either side likely expected, though the gallery, filled with more Brookstone Commons residents than either of us anticipated, made it feel considerably longer while it was happening. Priscilla Aoyama and Trent Falk seated together near the front. Karen's attorney opened by arguing the signage lacked adequate conspicuousness given the lot's proximity to the clubhouse, and that the fee schedule, while properly filed, represented an unreasonable rate designed, in his words, to entrap rather than genuinely deter. Priya's response walked the court through the statute's specific requirements point by point, entering the county's own filing confirmation for the posted fee schedule, photographs of the signage from multiple angles and distances confirming full statutory compliance, and, finally, Karen's own newsletter instructing residents to disregard the notice specifically because she doubted, without ever checking, whether it would hold up. "Your Honor," Priya said, "the defendant's own attorney is arguing today that this signage might not have been conspicuous enough." But the defendant herself never made that argument at the time. She told 240 households, in writing, that she doubted the signage would be enforceable, not because she'd reviewed it against the statute and found it deficient, but because she simply assumed a challenge wouldn't succeed. That is not a legal defense. That is an admission that she gambled with residents' own exposure to fees rather than picking up the phone and asking a single question. Judge Miriam Castellan, reviewing the full record, asked Karen's attorney a single question that effectively ended the matter before it had properly begun. "Counsel, your client's own written communication to residents states she advised them to continue parking on this property specifically because she doubted the signage's enforceability. Without any indication, she consulted the statute or sought legal review before making that representation to 240 households. On what basis does the association now argue the signage was somehow deficient, when your client's own stated reason for disregarding it was never that it failed to meet the statute, but simply that she assumed it wouldn't matter?" He attempted an answer about the board's reasonable reliance on community precedent, and Judge Castellan let him finish before responding with the particular quiet finality Priya had told me to watch for. "Counsel, I don't find community precedent a persuasive substitute for actually reading the statute your client was purporting to advise 240 households about. I like to move to ruling." There was no good answer beyond that because there wasn't one to give. The court upheld the fine in full, found Karen personally liable for the motorhome violations and the fees stemming directly from her own newsletter instructions, and awarded my legal costs, given what the ruling specifically described as a documented pattern of willful disregard for validly posted private property notice, compounded by the defendant's use of her official position to actively encourage continued violation. The court further referred the matter of Karen's use of official HOA communications to direct residents onto private property without authorization to the state's Common Interest Community Oversight Office, which, 3 months later, issued a formal censure and barred her from serving in any HOA leadership capacity for a period of 5 years. Karen paid the full judgment within 60 days, The motorhome, long since relocated to a proper storage facility, she'd apparently been avoiding the cost of the entire time this dispute had been unfolding. She did not run for re-election, and her resignation statement, circulated to residents the same week the oversight office's censure became public, mentioned personal circumstances requiring my full attention, and nothing whatsoever about the newsletter, the motorhome, or the fee schedule she'd advised 240 households to disregard without ever bothering to check whether her own assumption held up. Trent Falk, elected board president the following spring, approached me directly, not through an attorney, with a straightforward proposal. A modest, properly negotiated, insured license agreement allowing limited, clearly scheduled overflow parking on my lot during specific high-attendance community events, compensated at a fair rate, with clear liability terms neither of us had a guess about. Exactly the arrangement Karen could have proposed 14 months earlier with a single reasonable phone call instead of a newsletter inviting 240 households on a land that was never hers to offer. We signed it over coffee at the same shop where Trent and I had first sat down together, considerably lighter conversation than the one we'd had that first anxious afternoon, and Trent told me, folding the signed agreement into his jacket pocket, that the new board's first standing policy, adopted unanimously at its very first meeting, required any communication referencing use of property outside the association's own recorded boundaries to be reviewed and approved by legal counsel before distribution. No exceptions, a rule he said existed for exactly the reason it now had a name behind it in every board member's memory going forward. I still have that first newsletter, the one inviting residents to use the additional lot adjacent to the clubhouse without ever once naming who actually owned it, printed and kept in the same filing cabinet where I store every fee schedule and enforcement record from 29 years of exactly this kind of work. My wife Denise asked me once, not long after the settlement finally closed, why a half-acre parking dispute had mattered enough to me to spend 5 months building a case as carefully as I'd have built one for an actual client, back when this was still my job rather than my own land. Because for 29 years, I told her I watch people assume that a private property sign is just a suggestion, right up until somebody actually enforces it properly, and I don't know how to watch that happen on my own land and not do something about it the right way. She didn't argue with that. In 29 years, I don't think anybody ever really has, once they've seen the invoice itself. The lot sits quiet again most weekends now, exactly the way it did for the 7 years before Karen Ostrander decided an empty half-acre was community property simply because nobody had bothered to use it in front of her yet. The storage facility broke ground last spring, permits finally cleared. The same patient project I'd always intended it to be before somebody else's motorhome and somebody else's newsletter turned 7 quiet years into a 5-month legal reckoning I never once went looking for. I keep one of the original compliance signs, the first one I ever posted, in the same frame as that newsletter, side by side above my own workbench now, a plain rectangle of aluminum and reflective lettering next to a page of cheerful HOA cardstock that once told 240 households my land was theirs to use for free. I drive past the finished units most mornings now, the fence line repaired, the signage still standing exactly where the statute requires it. And I think more often than I probably need to about how completely an entire year of somebody else's confidence collapsed the moment somebody finally read the fine print instead of simply assuming it.